Now, what is the opinion, what is the main observation we found in the case of Indian Constitution? The moment we are talking about Indian Constitution, it is the Article 48A of the Indian Constitution and Article 51AG of the Constitution, which basically talks about that the state has to protect and safeguard the environment and forest and wildlife, and every citizen also has to conserve the same natural resources. In fact, Article 47 of the Constitution, they also talks about the standard of nutrition and improve the position of public health. Now, one thing which I have come across while observing these constitution provisions in India, and as per our Indian environment also, we have come across that the judicial decision plays a very crucial role. Starting from the case of MC Mehta versus Union of India, where they have been very specifically, the court has said that the state has to formulate the statutory regulation and has to implement the statutory legislations altogether while dealing with the complex problems of the environmental degradations. And they have talking about that we need to do something to subserve the common good principles. For example, if you refer another case, that is Municipal Corporation Ratlam versus Vardichan. So there in this particular case, one important point was made by the Supreme Court, that is the improvement of the public health. And apart from the improvement of the public health, it has been said that the human right to live in a hygienic environment is also needs to be recognized in the society. And that is not only one thing. They have also talks about that state needs to bring certain specific regulations, state needs to bring certain specific legislation to have a control over this public menace altogether with issues. Now, there is another case which I have come across, that is Vellore Citizens Welfare Forum versus Union of India. In this judgment, two important points which is mentioned, that is the economic development through the industries that should go hand in hand with the implementation and the principle of sustainable development. So, you see one thing with this in this particular case which is mentioned, that is the importance of precautionary principles and the importance of polluters pay principle. These two principles plays a very crucial role, and time and again it has been emphasized in MC Mehta versus Union of India, especially when you refer with respect to oleum gas leakage case also. There is another case which we have across, that is Indian Council of Environmental Legal Actions versus Union of India. In this case, it has been mentioned that the polluters pay principle is a very important for the maintenance of the ecology, but sometimes we face difficulties when we implement polluters pay principle. It is sometimes it may not compensate, it may not be proportionate in nature with correspondence to the risk factor and to the loss factor. So that's why it has been mentioned time again that the state will commit breach of trust when these natural resources has been given for the unauthorized commercial purpose, because time and again in our country these issues has been raised. Sometimes these cases go unattended, sometimes these cases they come before the court of law. So there these issues raised that when these lands should not be given for unauthorized purpose whenever there is a compromise with respect to environmental degradations. Another case which I am going to discuss, that is Rural Litigation and Entitlement Kendra versus State. Now, in this particular case, it has been referred the right to life includes right to live in a clean and healthy environment. And that is why this case is important, because in this case, apart from this right to have a clean environment, there is another point which is mentioned in this case, that is there is a specific direction given to these local authorities that they need to stop illegal mining, which violates the principle of natural justice, which violates the principle of natural justice for this local people who are living there, and it can also a matter where it can promote the environmental degradation also. Now, there is another case which you are going to refer, that is the Subhash Kumar versus State of Bihar. In this case, right to have an hygienic and nourishing environment has been referred, where it has been said that this come under the purview of right to life. And it is also said that the state and the municipal authorities do not forget to implement the target sets for preventing environmental degradation also. So, you see, in all these cases which we have referred, we have found out one common thing, that is the recognition of healthy environment, and that is we also talking about the kind of a reminder of the state has been given to in the case of to follow the active principle of state policy. It has also been important, we have know how environmental degradation has become a serious issue whenever the states wants to promote economic development, but at the same time they do not able to correlate between these two things, because you see in many of the cases which has been referred that these two things should go in hand to hand also. Now there is another thing which another topic which you're going to discuss, that what are the relevant legislations on these issues. Talking about the first legislation, that is the Indian Forest Act 1927. Now this legislation has described about the reserve forest, the protected forest, and they have also mentioned about forest offence. But unfortunately this forest does not deal with the conservation and the protection of the rights of the forest dwellers. But at the same time, with the passage of time, another legislation has come into picture in the year 1990, post-independence, Forest Conservation Act 1980. Now this legislation was introduced only for one purpose, that is to preserve and protect the country forest. And it has been mentioned that there are certain restrictions on the practice of the local authorities, that they will not use the non-forest land, forest land for the non-forest purpose. Now this has been specifically emphasized that if they really want to use these things, they need to take an approval from the central government. So these are the two issues, the two important observations of these Forest Conservation Act 1980. But in fact this Forest Act Conservation Act 1980, that does not deal with the rights of forest dwellers. Then with the passage of time, when different committees have emphasized and recommended upon these issues, in the year 2006, the Scheduled Tribes and other traditional forest dwellers Act 2006 was introduced, where the legal sanctity and the recognition of the rights of the forest dwellers to be given. And in this case, there it has been mentioned that the right to land for the forest dwellers for cultivation, for their livelihood, has been given to these forest use. And it is also mentioned that there are other rights which is also mentioned, that is the use right, where farmers can utilize the land for other minor forest purpose also. Then there is third legislation which is also very important in understanding the concept of human rights and the environment, that is the Public Liability Insurance Act 1991. Public Liability Insurance Act 1991, in fact it came into picture after the incident of Bhopal gas tragedy also. Now in this Public Liability Insurance Act, basically this particular legislation has placed a very has been established to give only one particular way, that is to provide prompt relief to the persons affected from the accidents while doing or while handling the hazardous substance also. So you see this particular legislation talks about the relief, this particular legislation talks about the compensation to those affected persons, where you can understand that it may be a case of irreparable damage also. So this was the challenge before the authorities, before the legislators, while framing this legislation. And in fact this legislation has also another peculiar feature, that is liability to impose on the owners, irrespective of the fact whether there is a fault, whether there is a presence of fault, there is a presence of negligence or not. In those cases, you see, when you handle these hazardous substance, the social interest, the overall security is involved, security of the public living in the surrounding area is involved. So that is why this Public Liability Insurance Act plays a very crucial role, in which the issue of no fault liability has been raised. Now another particular legislation which I am going to deal, that is the Biological Diversity Act 2002. Now this Biological Diversity Act 2002, it basically has come into picture after the Convention on Biological Diversity Act, which came into in the year 1992. Now after 10 years, when this legislation has come into picture, it has been introduced for three particular purposes, that is right to use the biological resources for the personal use, and it also talks about right of sharing of benefit for the indigenous communities. And the third point which is important, the third basic principle which is important for this legislation, that is the conservation and preservation of biological diversity with sustainability. Now these three principles, these three these three principles on which the Biological Diversity Act has come into picture. One of the important points which I have just mentioned, that is benefit sharing, how it can become a kind of a human right, how it can become a kind of a close importance for the close connections between human rights and the environment. Now this issue has become, and time and again when it has been referred, that in the case of biological the bioprospecting agreement, sharing of benefit plays a very crucial role, that whenever you use the natural resources, when you use the indigenous resources, benefit sharing seems to be one factor which is important, so that it can serve the common good principle, and so that the indigenous community who are totally dependent upon these natural resources will also get something for the benefit. Kani tribe is one of the prime example of how the benefit sharing has been given to these Kani tribe. So this is about the relevant legislations which I have referred about these things. So I hope all of you have understood the concept, starting from the international conventions at the national forums, and how the judiciary has played a very important roles. So you see, my concern is, the main important challenge before, while understanding the relationship between human and environment, is that the impact of this environmental pollution does not restrict up to a political one boundary. It can go beyond that also. So that is a challenge before international forum. And in fact, this point we have raised, that since there are many cases which go unattended regarding the unsustainable use of natural resources. So I hope you best of luck, and while analyzing this module also, and we'll try to analyze these issues, that how so far we able to connect with the indigenous society at the lower level, how so far we able to find out that there is a lack of access to fair justice for these indigenous communities also. Best of luck.